Lord, I had resolved to be calling judges only judges. Judge, on behalf of the petitioner, the ultimate relief we seek in the petition dated 5th September 2025
Yes.
is the invalidation and cancellation
Give
of
me
the
volume.
notice number.
Volume. Yes. If you could speak up, my volume is not so clear. Yeah, we are yes.
Thank you, my lord. The ultimate relief sought by the petitioner in the petition dated 5th September 2025
Yes.
is the invalidation and cancellation of the Gazette notice dated 25th August 2025.
Yes.
The facts are not in dispute, Judge.
Yes.
And the starting point is the replying affidavit sworn on the 7th October 2025 by Bernard Mogesa on behalf of the Kenya National Human Rights Commission. Allow me to highlight 3 statements out of that affidavit, actually 4. At paragraph 11, Bernard Mogesa has stated as follows, that the 19th interested party is mandated to receive and investigate complaints about alleged abuse of human rights and take steps to secure appropriate redress where the human rights have been violated. That's an admission by the constitutional entity entrusted with this responsibility. At paragraph 15, Bernard Mogesa continues, the aforementioned function vested on the panel of experts is a direct and blatant encroachment on the 19th interested party's constitutional and statutory mandates. At paragraph 26, Bernard Mogesa proceeds, the petition also challenges the relevance of the panel of experts within the context of the Constitution of Kenya, and in particular, the creation of independent constitutional commissions. And this is the ultimate testimony by Bernard Mogesa at paragraph 38, that mandate and functions, just like the jurisdiction of the court, flow from the Constitution and statute, and the same cannot be arrogated. Judge, those 3 factual depositions by the Kenya National Commission on Human Rights are dispositive of this contest. I've seen attempts to file a different affidavit to withdraw file submissions in order to negate this straight and narrow premise. Judge, you must reject that nefarious attempt because it is not only unlawful and unconstitutional, but it's a manifestation of one of accountability and integrity on the person currently holding the office of chair of Kenya National Commission on Human Rights. With that background, Judge, permit me now deal with what is the legal position. Article 59 of the Constitution has elaborated the manner in which Kenya National Commission on Human Rights is to undertake this specific function. The dichotomy between that independent constitutional body and executive was deliberate to insulate the commission from executive interference. Is there a deficit or paucity of the mode of effectuation of that constitutional mandate under 59? None whatsoever. Why do I say so, Judge? Because the Victims Protection Act has created the statutory mechanism to effectuate the exercise of this constitutional function. It's quite clear. The same Act, under Section 27, has established the Victims Protection Fund, from which public monies designated for this purpose are supposed to be domiciled. A question therefore begs, who has approved the budgetary allocation upon which this panel is to undertake this exercise? Nobody. Under Article 2 of the Constitution of Kenya, Judge, the President's powers are demarcated and limited. The President can only exercise authority given to him by the Constitution. If we proceed further under Article 10 of the Constitution, it becomes quite clear that presidential powers, whether in respect of policy or implementation, can only be exercised in accordance with the Constitution and the law. Interrogate this Gazette notice. Nowhere does it indicate the power upon which this transfer of constitutional functions is being made. Judge, two decisions are necessary to conclude this discourse. One is the case of Azimio la Umoja, Kenya Coalition Party versus the President of Kenya.
Is it somewhere? Is it somewhere in your submissions, Kotka?
Submissions yes, it's at paragraph 8 of my submissions. Paragraph 8, my lord, of my submissions. 8 of
submissions by the first petitioner. You have
and my lord, because I'm within my permissible 10 minutes.
Yes.
Permit me to read paragraph 140 of that holding. This is what the learned judge of the High Court, your brother, stated. On the basis of these findings, I'm satisfied that the President assigned the Commission of Inquiry into the Shakahola tragedy a mandate that the Constitution specifically set aside for independent constitutional bodies and officers as demonstrated in the foregoing. Hook, line, and sinker as it is in this case. The definition judge that reliance is made upon is domiciled at paragraph 9 of my submission. That is the case of Benjamin versus Attorney General. The others, that is the Maraga case. This is what your brother judge stated at paragraph 92, that decision, which I've extracted at paragraph 9 of my submissions. Be that as it may, the President cannot, under the guise of exercising executive authority under Article 129 or 131 or 132, assign specific functions of an independent constitutional commission to any other body or person. Lock, stock, and barrel, as it is in this case. In conclusion, therefore, Judge, it is a matter that is not novel. It is a path that has been trodden time without number. The President, as the head of the executive, cannot arrogate the powers of a constitutional commission, in this case, the Kenya National Commission on Human Rights, for nebulous entity conceptualized and conceived from his imagination. Judge, you must therefore of necessity allow this petition, declare the Gazette notice as unlawful and unconstitutional, and proceed to quash it with an order of certiorari. There's been a practice where courts do not grant cause, but we have a case where the President keeps on daring the Constitution, keeps on daring the rule of law, keeps on daring the legitimacy of the judiciary. We therefore plead with you, Judge, to order the payment of costs to the petitioners by all these respondents and the interested parties, save for the 19th interested party, who has done the correct thing of supporting this petition. We so beseech you, Judge. I'm most obliged.